Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment, it was forged by law within a unique justice system born from the union of the civil law and common law and increasingly Indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to Indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments. Justice Jamal, a very warm welcome. Thank you for being with us.
Thank you for having me.
We are in the magnificent building of the Supreme Court of Canada, where you were appointed in July 2021, a key moment as you became the first person of color to serve on Canada's highest court. You were the first in your family to attend university, earning law degrees from McGill and Yale before joining the bench, first at the Court of Appeal for Ontario in 2019 and then the Supreme Court. You had a distinguished career of over 23 years as a litigator, appearing before the Supreme Court no less than 35 times as counsel. Your commitment to pro bono work and legal education has also been a significant part of your career. In your advisory board interview for the Supreme Court, you said, and I'm paraphrasing here, anybody who is from a racialized community, a minority, has a tremendous responsibility, so I'm very mindful of that. They can see their own faces reflected in the justice system. You mentioned a tremendous responsibility. How does that responsibility most directly guide your day-to-day work as a judge?
Well, I think all of the judges of the court have a responsibility to do their best to interpret the law and to help apply the law to the concrete situations that come before us. When I was appointed, I was contacted by many young lawyers, students, and other Canadians, many who were immigrants or visible minorities, and they told me what my appointment meant to them. It came as something of a shock to me in terms of the impact that it was having on other communities. This is an opportunity, not just for me, but for them and for their children. I think we all share, all of us, all 9 of us, share a tremendous responsibility to the institution, to the future of the Constitution, and fidelity to the law. I think we share in that endeavour.
Your contributions since joining the Supreme Court have been significant. In 2022, you dealt with key charter issues. You explained that police arrests must be based on the law as it is. You also determined that even if an arrest was based on police misunderstanding of the law, the evidence collected could still be considered admissible. This really brings out the delicate balance between individual rights and state authority. How has the court dealt with these issues?
Well, it's always a balance, particularly in criminal cases where we're often asked to adjudicate the rights of an accused, which could be any Canadian who's challenging state authority in the criminal context. Often it would be search or relating to other rights that were implicated, whether their right to counsel, whether they were detained unlawfully or unreasonably. So that's important, that individuals have rights, but it's also important as part of the balance that we maintain appropriate powers of the police and other state authorities to investigate offences, because that is their responsibility. And we always try to strike the appropriate balance between protection of individual rights with the needs of the public to have serious offences investigated and prosecuted where appropriate. So that's the balance that we're always striking, particularly in criminal cases. But really, much of adjudication, much of judging is about striking a balance between competing principles.
You've said in the past the only unifying principle that seems to stitch your life together is an abiding belief in pluralism. Can you tell us a little bit more about that?
My life and my experiences are shared by many Canadians, many immigrants to Canada. And so pluralism is very important, that having a diversity of perspectives and experiences is very, very important. In my own case, I came to Canada as an immigrant in my teens after my family having immigrated to the United Kingdom. So that was a part of the diversity of my experience being an immigrant. Obviously, as a visible minority or racialized person, that's part of the diversity that is part of my experience. Part of the diversity that I experienced as a student in law in Montreal was also working in a city and a province of linguistic diversity where both French and English are spoken, unlike where I'd grown up in Edmonton. So those aspects of diversity, there is also, of course, religious diversity. And I look at all the things that connected my own experience, and it was this belief in pluralism, legal pluralism as well, that both the common and the civil law and Indigenous law as foundational systems of law in the country are valuable and worth exploring. And we have the great opportunity and responsibility to explore all these forms of diversity in our adjudication and in our analysis of the legal systems that come before the court.
Your path is marked by many different international experiences, as you just said, and a strong involvement with Canadian law, both as a lawyer and now as a justice. As the court reflects on its history, could you share with us how your unique personal journey and the perspective you've gained from it shaped your approach to understanding and applying the law and engaging, obviously, with the diverse realities of Canadian society today?
Well, I was fortunate to study law in two countries, in the United States and in Canada, and that necessarily informs the way you see the law. I think studying the law in a foreign country allows you to gain a deeper appreciation of your own legal systems. It also allows you to see the possibilities of comparative law, of learning from another jurisdiction's experience. That was certainly part of my experience studying in Montreal at McGill, where we had the opportunity to study both common and civil law and see the value of looking at legal problems from the perspective of another legal system. So part of it is internal within Canada, but part of it is also external and looking internationally. I think drawing on those experiences is always valuable, and many of the judges of the court have similar experiences of studied abroad or studied different legal systems. It gives you a better appreciation of your own legal system and to look at how a problem has been approached elsewhere. And so that's something that I've been fortunate to have experienced as a law student and as a lawyer too, as a practicing lawyer. I was frequently dealing with lawyers in other jurisdictions, whether that was in Japan or the United States or in Europe. And so drawing on their perspectives as we approach legal problems, I think allows you to have a better toolbox as you approach what is fundamentally an exercise in problem solving. Lawyers and judges are essentially problem solvers. We are given a problem to solve. And the more tools that we have to solve those problems, either domestic tools or international tools, the better problem solvers we will be.
As we face new challenges, mostly technological, and the rapid pace of change that we are seeing right now, what are the most important things for the court to consider in upholding the Charter's balance between individual rights and state powers? And if I could add to this, what important past decisions, perhaps early Charter cases, I'm thinking Hunter v. Southam, do you see as especially important guides to move forward?
Our system of law is built on precedent, which means we look for analogous situations in prior decided cases. And when we're looking at the Charter, we start with the prior decisions, which is since 1982. The Hunter and Southam case is 1984, a decision of Justice Dixon, as he then was, who was later Chief Justice. And it was one of the early decisions dealing with the interpretation of Section 8 of the Charter. Now, Section 8 only says everyone has the right to be secure against unreasonable search and seizure. Hunter and Southam dealt with whether or not competition authorities, in the context of an investigation under the Combines Investigation Act, which was the former Competition Act, had the right to enter business premises on the authorization of the Director of Investigation, who was a regulatory authority, without a search warrant issued by a judge. And so the issue was whether or not regulators can essentially authorize entry onto private property and to do a search. Justice Dixon, in a short decision by modern standards, 25 pages in the Supreme Court reports, looked to American jurisprudence. We talked about the value of looking abroad. Looked at earlier Privy Council jurisprudence and Viscount Sankey's famous statement about how the Constitution is a living tree, and said that The right to be secure against unreasonable search or seizure, which is the specific guarantee in Section 8, also protects fundamental right of everyone to privacy, a reasonable expectation of privacy. And from that right to privacy, Justice Dixon said that when you are going to be entering into private premises, we have to consider the needs of law enforcement, but we also have to consider the protection of individual privacy. And in those circumstances, the right balance would be affected by the requirement of prior judicial authorization, a judge, not a regulator, granting a warrant on reasonable and probable grounds. So from that early decision on the interpretation of Section 8, all Canadians had a reasonable expectation of privacy protected. Now, that was in 1984. Since then, Section 8 has been adjudicated many, many times in the criminal context, in the civil regulatory context, and we always look back to Hunter and Southam, but we build upon it to evolve the right to privacy, to deal with that important tool and use it to help solve current legal problems. One such legal problem is whether you have a right to privacy online when you're searching the internet. Spencer or the Bajkovic decision. So we have to apply these broad principles, broad language of the Charter, prior adjudication to deal with pressing problems that come before the court, dealing with new technology that wasn't contemplated, that didn't exist at the time the Charter was enacted in 1982. So that is the task that we have, to look back at our precedents, but also to say, how can we adapt this to deal with the reality, the social problem that we have before us in a specific case? That is the task of adjudication and of judges in applying the Constitution and prior decisions to new situations as they emerge. I think we have the tools. We have a great court, and it's like a relay race. We are given the baton from our predecessors. We take it forward for a period of time. We try and protect the institution. We try and protect the law, and then we pass the baton to somebody else. We are temporary custodians of the Constitution and of the law, and we pass it on to the next generation when our time is done.
Justice Jamal, thank you very much for your insights and for sharing your experience with us. And happy 150th anniversary.
Thank you.
Thank you for joining us for this episode of Shaping Canada, 150 Years of Landmark Decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of the series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project: the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Cazirer, Suzanne Côté, Andromaki Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmud Jamal, Michel Obonzawin and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Carrie Frock, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Bakken, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.